Hey everybody, we're getting ready to get started. We have one more minute. Let's see if anybody else is going to join. But in the meantime, I am going to go ahead and get to my forms and everything that we're going to be using to do a basic listing contract. So let's go here. Let's give it one more minute. I think I'm pretty much ready to go. I've got Forms of Russ up. And of course, for the new people, you should have received your login from the board. And of course, it's your username, which is usually your name, and your NERDS ID. So, again, for those that not attending, this will be available on our Facebook page and also our YouTube channel. So it's 1 o'clock, so we're ready to go. Okay, so the very first thing you're going to do is, of course, go to, let's go ahead and minimize that. Go to the URE intranet to reference and make sure that we pull up the appropriate checklist. This is always best to do the first thing so it keeps you organized. And what did I go? Hold on. Here we go. Sorry about that. I meant to make it bigger. And the very first thing you want to do to make sure that you're organized and you have all the appropriate forms. Okay, so the following documents should be kept by you and loaded into the paperless pipeline 7 days after it being fully executed. Fully executed meaning all signatures. Please note the items in bold are required for all contracts. Other items are as required per the agreement. The same thing true with the sales contract. Every deal is going to be different. So, different things are going to take place, different forms. Okay, so the very first thing, of course, is the referral agreement. That's only pertaining to if this particular listing was referred to you by another agent, another broker, or in-house, or whatever the case might be. The next thing that we're going to have is an MLS agent-only format initialed by the seller. So let's just say you've got everything filled out. Of course, we're going to go to the complete packet here in just a second. And you have, executed the listing agreement. You put it into the MLS and photos within, I believe, 24 to 48 hours. You have to have a photo. MLS exempts are when you're going to do some different rehab and the property is not ready to go fully marketed and fully exposed. And I'll get you the dates on those precisely because Maris will ding you every single time. Now we have the coming soon. So I believe the coming soon is fairly new, and I think it's 7 days within the listing agreement. But let me get you those exactly, and I will post those on the Facebook page as well. So the MLS agent only format is the purpose of that is to have your seller fully take responsibility of what you're marketing on their behalf. So it's a great opportunity for them to, give you the okay, everything looks good. No, you forgot this. Let's add this. Do you like my verbiage? Do you want me to change it up a little bit? All those kind of things. So I suggest that you do the MLS agent only format immediately upon entering it and making it active. The reason being, I'll tell you a story, and I'm going to use a lot of this when I go through these trainings, is that if you forgot something like a sump pump, or wait, hold on, you put on the MLS agreement that it has a sump pump and it doesn't have a sump pump. So an agent comes, you write an offer. Although the MLS is not always part of the contract, and we'll talk about that in a little further detail, or if you've watched the residential sales, it can be part of the contract. So bottom line is this. You're still responsible for what's in there. So if there's not a sump pump, for instance, the buyer's agent goes, well, hold on, wait a minute. My buyer made that offer based on the fact that it has a sump pump. Well, who's responsible? You didn't have the seller okay that. You did it without the seller's initials. You're ultimately responsible for that information unless you really kind of want to, at a cost a deal. And there's never a good way to proceed like that. Okay? MLS exempt form, if applicable, we'll go through a whole entire class on coming soon and MLS exempts. That will be the next one. Tax records, everybody goes, come on, Janice, why do I have to have all this paperwork? Why is a tax record important? Well, a couple of things. This is always best to pull as soon as you have the listing appointment set up. You're going to verify how the property is titled. You're going to verify who is on or who is authorized to sign the listing agreement. So that can be out there in the open. And another thing to consider is how that property is zoned. When I was managing a foreclosure company, the admin put it in as a residential listing. It actually was zoned commercial. It was sold as a residential listing. And guess what? Day of closing, the buyer went to St. Charles to get an occupancy. And they said, sorry, guy, that's not a residential property. That's a commercial property. Huge, huge deal. So you want to verify square footage. You want to verify all this information per the tax record. And it's also good to bring that to your listing appointment because you want the seller to know that you have access to that kind of information. And it's all verifiable information, mortgage history, everything is on there. Unfortunately, you will be hopefully never in the situation, but at times there are some people that are kind of devious and they try to pull a couple of good ones. Divorce situation, girlfriend comes and signs instead of the wife. You just don't know. So it's better to have all your ducks in a row. Okay, we're going to go through the listing contract and actually fill one out here shortly. We have the exclusive right contract, and then we have exclusive agency. The difference between those two, and we're going to be filling out the most usual, the most common one, is this exclusive right to sell. That means that the broker is exclusively representing the seller, and as in the exclusive agency, the seller still retains the right to sell. On exclusive agency, the seller can still sell that home on his own. Okay? It's kind of a neat little marketing trick with for sale by owners, but we'll talk about that in one of our lead gen classes. Okay. Seller's disclosure. Seller's disclosures are always best uploaded to the listing when it's filled out. You never, ever fill out a seller's disclosure. It is to the seller's best knowledge. Now, on the buy side, I always emphasize to the buyers, Mr. and Mrs. Buyer, a seller disclosure is basically a great idea to the seller's best knowledge. But you know what? A seller is not an engineer. A seller is not a contractor. A seller is not necessarily knowledgeable of the systems, electrical, HVAC, roofing. It's to their best knowledge. So this is a great opportunity, of course, to emphasize again that it's always best to proceed with an inspection. Now, hopefully you covered all this with the buyer, speaking of inspection, with your buyer consult. Okay, so you send the seller the disclosure, have them fill that out and make sure that you pick it up, because most agents are very uncomfortable writing an offer because honestly, there could be something disclosed on there that would affect the offer price. So make sure you get that done. Lead-based paint, any property built prior to 1978. There's a lot of go back and forth on this. A lot of people believe, well, why should I fill out a lead-based paint if the property was built, well, let's just say new construction. The thing of it is bear in mind, there's two schools of thought. It is a disclosure. So unless you indicate somewhere in the listing agreement or on the listing, which you do, because you have to do year built, it's always just best is to go ahead and, got to pick our battles, go ahead and do the lead-based paint disclosure. Most buyer's agents will ask for those just as formality. But again, I did call the MREC on this one. If you disclose somewhere that the home was built after 1978, you don't have to do one. But I'm just telling you, just go ahead and do it. Authorization to release of information. That is a document that I personally made that you are kind of disclosing to the, have an opportunity to talk to seller. What do you want me to talk about? What can I disclose? Another big thing is when you've got the home on the market and you're receiving offers and this and this and that. A lot of people are the assumption that we're not allowed to disclose a previous offer. For instance, I just listed something, got 3 offers. The agent, you can tell she's seasoned. She goes, "What is the offer?" Now, with your seller's permission, I can say to this agent, "I've got an offer at full price at $124,900. You need to beat that, or you need to beat the closing date, or whatever the case might be." This is an opportune moment to talk to your seller. What can I say? Can I say more than you're motivated? Can I say that you'll be more aggressive with a contract at a certain price of a closing date? So this is the kind of thing that you can know up front, and what a great opportunity to best represent your client when you get permission to disclose that and you're in a bidding war. It's highest and best. So, okay, so that's a little thing we'll talk about more when we're talking about negotiations. But yes, you can disclose anything with your seller's permission. Exception: you cannot disclose, because you are not an expert, unless there's a report to validate it. I would stay away from foundations, roof. Again, we're not building inspectors, so be very, very careful with that. Missouri broker disclosure. Of course, we talk about agency. It's important to know, and this does come up, that your seller, you have to explain what your role is. Agency is a great way to start with that. So do you exclusively represent the seller? Are you a transaction broker? So there's an opportunity to go into that. So I like to see Missouri broker disclosure. I like to see them initial right next to what you're offering them as agency. It says here, if applicable, representing purchaser. I'm going to change that. I'm going to delete that. You need to go over agency in every situation, every single time. Okay? Again, Missouri broker disclosure, have them initial what agency, right next to it, circle it, put an X there. This is my role in this transaction. Okay? Listing amendments, this is an old checklist, or electronic communications. That is not existing now. We need to take this off the checklist. They actually put those in the listing agreements. Speaking of that, and we'll talk about this when we start filling it out, the email has to match. In the court of law, if something comes up, you only can communicate with that email. Texts do not count. We'll talk about that in a little bit. Any additional disclosures pertinent to the home, okay? Once the listing goes under contract, please refer to the selling checklist to turn in all your contract sales packages. Okay, so all that is pertaining to that is in bold. There's no exceptions to that. And make sure, again, the MLS is initialed by the seller. They get to confirm commissions, all that. Very, very important on the buy-in too. Okay, of course, any questions, let me know. Let's go ahead and let's see if I got my forms or us. It's probably on my Google. 1 second. Here we go. Okay, so we've logged into Forms of Us. One of the things that I recommend highly to save time and to save your sanity is to go ahead and go ahead and create these listing packets before as a basic packet so you can just have them ready to go. We used to need, in the old days, and some agents still like them, they like to do hard copies. I want to discourage you from doing that because forms change so much. One of the first things that the MRC looks for in an audit is updated forms, and there's an expiration date and a revision date and all that. So always use your online forms. Okay, so let's go ahead and go down. You can say listing. We're going to go to the listing contract. This is our exclusive right to sell. So we're going to pretend, I'm writing a contract today. So of course it's going to be today that we enter into the agreement, which will be here. Okay. Another thing, again, when we have this line here, same on a sales contract, is how that person is legally titled. So we're going to say Jane Smith and Don, I don't know where I get these names, Smith, and they are a married couple. So it can be a single person, it could be, usually it's either a married couple or a single person. So it kind of helps that the title company kind of look for that and kind of gives them a heads up. Okay, so municipality, let's go ahead and stay out here. Let's go to Wentzville. And it's a county of St. Charles. For the city properties, of course, you got your municipality, but the county, you just put city. Okay? So we're going to do, let's go ahead and do 123 Walnut Street. Here, I would go ahead and do the entire, even though we've already got it listed, I would still readdress Wentzville. Full legal address, Missouri, 63385. Okay. So here we're going to, oops, I missed my line. We're going to go ahead and list this property for $250,000. That's a nice price. Okay. Or if any other price to which owner shall consent and under following special terms, if any. This could be, let's see where this would come into play. Maybe just for an example, you can do $245 if you close by, a specified date, or any other kind of incentives that you could kind of recommend, or if there was not including furniture, or just a bunch of different things. So special terms is going to be discussed between you and seller, and there could be millions of them. Usually there isn't a lot of information here. And so let's go on down. Of course, he's making it perfectly clear that, and you've already looked on the tax records, that he has a legal right to sell the property, and that he has all sufficient funds, all loans secured by the property, liens, closing costs. Of course, if the short sale, we're not going to go into that today, but if the short sale supplement to the listing agreement. So there's some different things. So make sure that you've asked the right questions. Is there a second mortgage? Is there, are you past you behind in any payments? So again, we always hear about a buyer consult. It's your job to ask the right questions to make sure you are painting the right picture when you market this property. Okay. Owner agrees to pay said realtor a commission of blank percentage of the total sales price. Believe me, they get very confused in this. I always get a piece of paper. I put listing broker on one side, selling broker on the other side. All commissions are paid to the listing broker. It is the listings broker legal responsibility to disperse the commissions. Now, what has happened in the market today, we specify our title companies to do that, but ultimately it is a listings broker responsibility to make sure that happens the way it's supposed to happen. Okay, so this is a question I used to get a lot from the seller. You know, you'll give them a number on the commission side. They don't understand that you are going to pay the buy side. So make sure that you make that perfectly clear that you're going to pay out a 2.7% commission to the buy side. Now, this is very, very important. We don't determine what commission you charge, unlike the traditional brokerages, which it is determined for you that you cannot charge any less than, let's just say, Coldwell Banker, 6%. I think Berkshire is the same way. REMAX is usually a 5%. Key, you guys, know your competition. You've got to be able to compete in this market. And so you got to know what everybody else is doing. One of the advantages of 100% company, of course, is that you have a little bit more leverage because you're keeping more of your money. One thing that I have a huge pet peeve on, market indicates that 2.7 is 99% of the time is what paid to the buy side of the transaction. Unless you have a high-end property, don't cut the buy side out. Even though you're right, it's a seller's market right now, but we don't want to position ourselves as that company. Okay, we're not a discount brokerage in the fact that we want to discount the buy side. All right, so so again, when you're pricing out, you have to be competitive. Always ask on a listing presentation, who else? Now, there should be a phone call, but not when you get to the house necessarily. Who else are you interviewing to list your home? So then you know what you're competing against. So if, I even ask the agent's name. They're sometimes reluctant to give that, which I don't know why, but they just are. But if you're competing against a Keller Williams, a REMAX, more than likely they're not charging a 6 and 7%. If you're competing against a Coldwell Banker or a Berkshire, more likely they're charging a 6%. But so you have to know what the weaknesses of the other companies are and their strengths. So when you go in to compete for that, you know how to position yourself. So we're just going to say we're going to do a 5% here. Okay? Percentage of the total sale or lease price, but not less than a minimum commission. Okay, so you got to think about that. So what does that really mean? Do you want your admin costs? You want to be assured that you're going to get your admin costs. Do you want to be assured that you know what your marketing dollars are, or how much time depends upon the product, the home that you're listing. So, let's just put in here for today, it's going to take you an hour and a half. You're going to put it syndicated on all these sites. You have professional photos, all this, so we're going to put in here, I don't know, $750. I have yet to execute that, but it's always, you have to put something in there. So just think about that. And what's worthwhile to you. Okay, that's a minimum commission that you'll accept under any of the following circumstances. Number one, if by 11:59 p.m. this blank here is going to be your listing termination date. Okay, again, it's a seller's market, but I still go out 6 months. You just if you have any flack on that, take it out in 90 to 120 days. Bear in mind, it's going to take you that long to close. Okay, so let's just go ahead. We did it 6 months, so it's going to be 6 months from now would be 12/21. Sounds weird, doesn't it? 12/21/2017. Now, again, if that's a hot button for your seller, this is going to be a conversation. It's almost silly to do it in 30 days. But, in this market, you should have some action on that property if it's listed right, if it shows well. So be smart about your business. Don't commit to something that logically doesn't make sense. Have that conversation right now. Sure, you can get an offer on this property within 30 days, easy. If it's priced right, if it's marketed right, if it's an as-is property, condition, consider all those factors. That all determines price and time on market. Okay. Here after the termination date, a ready, willing, and able buyer is procured by undersigned realtor or by owner or by any other person, or the termination date, the property is contracted by us to be sold or leased, or 3, within an additional term of. This is key. This is a protection period. So let's just say, for some reason, everybody wasn't on the same page with this listing, and the seller asked to be released from this agreement, which I recommend. I never try to hold somebody to an agreement that, one, is not realistic or just hard to work with. Life is too short, guys. But also, let me tell you this. You cannot sign the mutual releases. The conversation should go like this. Understand, I'm sorry, we couldn't come to terms, blah, 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 whatever you want to say given the circumstances, but my broker has to release you from the contract and sign the mutual release. Okay? So in here, so let's just say that happens, and you've had 15 showings before this happened. So you need to make sure that you give that seller a list of people that came through that property when we had it listed, because if those people come back within a certain protected period, although they're listed with another broker, you are entitled to the commission. So that's where this comes into play. Is it $750? You say, no, wait a minute. No. I want $1,200. Whatever the case might be. But you have an additional protection period after the termination date, which will be in writing, of, I usually put 60 days. Okay? So, and if they lease it, hopefully if they're going to decide to lease it, for some reason the property won't sell, they'll hire you to lease it. And then, of course, on a lease, you might want to change this number here. So all those things are taken into consideration. If you have any questions, of course, I'm always available to answer those. Okay, so let's go on down to line 25. And this is kind of a good one. This is something to think about how you want to run your business. But the owner agrees to pay realtor additional compensation of blank. This portion of the additional compensation shall be due and payable to the realtor either the effective date of this listing contract, and this is regardless of whether a buyer is procured, or only if on the same date the other compensation all above provided is payable. So that could mean either this amount here, and it'll be in addition to, or it could be at the time of closing. Okay, so you're thinking, when is this compensation? What does this mean? What is this compensation for? A lot of agents use this as here, effective date of listing contract. Let's just say this guy really wants some pretty sophisticated marketing done, and you want to buy in. You don't want to procure other costs. Let's just say, it's a great highway positioned property and you want to get a billboard, or you want to advertise it on, Lands and Farm or different venues that is not the normal syndication for our Maris. So this is where you put here. Or this is an opportunity for photos, for video, for, a lot of different things like that. So that's the amount would be here. So let's just say it's photos. You're getting photos done for $150. Now, you can ask him for the buy-in because let's just say the guy's overpriced. Let's just say there's no well between you and I. This property is going to sell at this particular price, and you really don't want to, put all the money up. The guy's not reasonable, whatever. You probably shouldn't take the listing then, but that's another conversation. So you want the photos reimbursed. You want them up front. So you check this box. Okay? Another situation would be you charge an admin fee. Your business model is you have an administrative person that you want compensated and you charge X amount of dollars a deal. So I would never, ever go over $495. This is a creative way also to get your fee covered with United and have the buyer or the seller go ahead and pay for this. So let's just go $295 isn't a reasonable amount. And you want it paid at closing. So this will be addressed on HUD. It should be a separate line item. And then also this would be addressed on your commission sheet. So, this could be $395. Now, legally speaking, because there's a certain large franchise that really got in a lot of trouble and fined $83,000 for this, but you really should have a description of what this fee is for. It's just a better way to run, business. You can have a description of your administrator, your transaction person, whatever you want to call them, and what their responsibilities are for, because this is what this fee is going. I think that is the best way to do it. Okay, so let's just leave it that we're paying our admin that, and we're gonna go ahead and be happy with that fee being reimbursed at closing. Okay. All right. Total including that limit to. Let's go on down. On line 36, I want to emphasize the owner represents that, except as noted on the seller's disclosure statement, you're asking him again, owner knows of no actual or proposed special subdivision or condominium assessments, no structural material defects, or any material facts. Again, you're asking him that this is very, very important for him to disclose everything and anything that pertains to, again, here, mechanical elements, appliances, anything that is being offered and that could affect that offer. Anything. Proper working condition. I recommend that you do most appliances as is condition, because they're going to be responsible for that. So this is the time that you have those conversations. Okay. And anything he puts in the seller's disclosure will be signed and made part of the contract. So he's responsible for that. Okay, remember when I had that quiz, everybody that came to the last sales meeting, and no one knew, and here it is on the listing agreement, that section 339. 339 is licensing law. So that's where it really gets to be a situation that we're responsible for anything we say and do per licensing law. So it goes into here. These are our responsibilities. Brokerage services under the exclusive right to sell. This is what we're obligated to do. This is what we're obligated to do as a dual agency. So agency is going to be an entire class within itself. Of course, we're only allowed to act as a dual agent with consent of all parties to the transaction. Some people don't want you doing that. So that's when you bring in another designated agent to act on the behalf of the buyer, because you've already got the information from the seller. That's when you ask me to come in and act on the behalf of the buyer. Or sometimes with some companies, this can default to a transaction brokerage situation. That's a little bit more difficult because you've already been disclosed probably a lot of information by the seller. So very rarely does that happen. When that can happen is when maybe in a bank transaction when it's a foreclosure. Okay, so I'm not going to go through every single one of these, but this is a great example or an opportunity to have that conversation with your seller of everybody's role. Okay, so remember, we've already shown in the Missouri broker disclosure. This emphasizes it again. Okay, 75 through 77. If designated agent is appointed in accordance with this agreement, dual agency does not occur unless one of the two exceptions described in the designated agent. Again, referencing to the Missouri Real Estate Commission broker disclosure. That's why every single transaction, I want that introduced in the beginning. Okay? Now, of course, they say, well, when the MREC does an audit, do they look for that? No, they don't. But me as your broker, I say you have to have it because think about it, guys. We're already here to the listing agreement. And on the buy side, we're already into the residential sales agreement. We've already found out about their financing. We already know if they have a second. We already know maybe they're going through a divorce. We've already got personal information. So what's the point when we're ready to contract? Do it in the beginning. Do it in your consultation. No exceptions. Okay? So let's go ahead and go to 3. This is what your owner agrees to. One of the things that's come up quite a bit lately is utilities. Your owner is agreeing to leave on all the utilities until the buyer has possession. That's come up twice and some contracts in the last couple of weeks. Make sure that your owner realizes the responsibilities that he has to maintain the property in good repair through the date of closing. Mow the grass. That happens a lot in vacants. Keep the utilities on. Make sure that people have reasonable times to show the property. Let's just say you have a seller that is a night worker. That might present a problem. That might present a challenge. You have to get on the same page with showings. I've had people that have renters in the property. Make sure all this is discussed up front so you can properly set up your showing assist. Number line 87.6, to promptly furnish realtor with a copy of any available survey report. Kind of have mixed feelings on that one, guys. How old is the survey? Has there been any improvements? How do you know it was a reputable survey company that did it in the beginning? I mean, again, take one of Shelley Clark's survey classes and for CE, and she will scare you to death. I want the most, if I'm representing, I want on the buy side to make sure my buyer has the most up-to-date information. You will be asked for these. So I say proceed with caution. Maybe have, Shelley from Cardinal take a look at it. Maybe have Bill DeBoer from Meridian take a look at it. I just be really careful with that. Okay? And again, owner authorized realtor, to use all reasonable recognized professional practices. We all as brokers sign an agreement that we will share the listing and co-op with other agents. So number 4, place a suitable sign on the property. You guys, there will be some circumstances, condos, some sellers just don't want their neighbors to know. Whatever, you're dealing with human beings here. There's going to be an array of situations. Make sure they're aware that you are going to place a sign on the property, that, you are going to market it this way. You are going to expect them to do a flood letter. give the information to the title company. That's another thing. I don't personally take personal information, social security numbers. I give them a heads up that my title company is going to be contacting you for your payoff. I leave a mortgage payoff, which we should have one in reference. I leave that with the owner, and set the expectation that the seller, the company, title company will be contacting them. And now they came up with, and it's on Forms of Russ, a beautiful, and we'll look at that if we have enough time after this, a beautiful, I think it's 3 pages for your seller to fill out. I have them fill that out and send it to the title company. Another thing is, are you going to use a combo box? Are you going to use a super box? I personally like combo boxes. Some sellers want you to do a Supra. The advantage of a Supra is you can actually see when they get to the property. You can actually see when they leave the property. And if there's any indiscrepancies with any issues, the Supra is a great tool to have because you'll have those reports. Okay. And you go through here, or owner acknowledges. I send this before, if I've got a listing and I know that we're going to be moving forward, I send them a sample, and I literally write sample across it, and I let them read through it, and then be available for any questions. Okay. Here we go. This is that little thing with cooperation compensation. I actually offer everybody 2.7%. Now, we are being blessed, I guess, and somebody's point of view, that we're in a seller's market. Now, the thing is, you're going, well, why wouldn't you do that? Now, when you go look at your MLS sheets, be sure you pay attention to payouts if you're representing a buy side. Now, I will compensate anybody that brings, especially if I'm doing a new construction listing, I'll compensate anybody who brings me a buyer. Okay. Now let's talk about this a little bit. This is a reason why some agents don't want to do it. Buyer's agents, full representation to your buyer. Of course, you're going to pay them 2.7%. They're going to do all the work, right? They have the fullest responsibility to your buyer. Transaction brokers, for lack of a better term, represent the transaction. They don't necessarily are going to know if somebody's going to build a shop and save behind your house that you're trying to sell. Okay, of course, you should disclose that. You're responsible for disclosing that. But for lack of a better term, and we'll get into this a little bit when we do the transaction contracts, is transaction represents the deal, represents the paper. You have to do honesty. Anything that you know, you have to disclose, of course. And there's a separate set of responsibilities to that. Now, sub-agents means that they don't have a buyer's agency. Some of us old school agents, we never had buyer's agency. We represented the seller, but we really represented the buyer. So there was a lot of legal issues with that, a lot of disclosure issues. Nowadays, you very seldom see someone bring a buyer without a buyer agency. But it does still happen. It's on the listing agreement. So that, in essence, if you have a Keller Williams agent bringing you a buyer, and they don't have a buyer's agency, and I don't know a lot of listing agents that ask, do you have a buyer agency necessarily when they present an offer? That means that Keller Williams agent is representing your seller. Not so good for the buyer. Okay. Number 7, warranty, not offer a warranty. I always set up my seller at this point. Listen, Mr. and Mrs. Seller, more than likely you're going to have a buyer ask for a warranty. If you don't want to make a decision now, I brought you some samples of, what a warranty looks like. In addition, maybe some links to some websites. Never, 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 ever never answer any questions about warranties. Let them read it on their own. Last I know, none of you guys are selling warranties. You're not an authority on what a warranty will cover. If they are a high C and they want all the details, refer them to the warranty representative. Do not answer the questions. Okay? So here, some seller, my last listing I just did, they said, well, of course I know they're going to, ask for a warranty, but I still ask them to consider at a later date. I use the warranty as a negotiation tool. It's usually about a $500 value. So that's part of the net that your seller is going to have. Let the buyer ask for it. Don't offer it. Let the buyer ask for it and make sure that buyer's agent knows there's a $550 value. You guys learned that on your sales contract class. Put a monetary value to these for your seller even. Mr. and Mrs. Seller, this buyer is going to come in at X amount of dollars. Here we said $250. They came in at $250, but they're asking for $4,000 in closing. They want a home warranty valued for $550. Right? Go through the net proceeds. Let them know what they're really negotiating. They'll see most, even buyer's agents, it cracks me up. They'll see, well, wait a minute, I offered for a price of $250. No, you did not. Mr. Seller, no, they did not. They're asking for closing costs. They want a 60-day closing, which means you're going to make another payment. So we'll go into that more when we go into the net proceeds. So I said we're going to consider that a later date. Let the buyer ask for it. Okay, so we're going into duties and obligations. I recommend you guys, I'm not going to go for lack of time. I'm not going to go through every single line of these. I think this was in, you go through a lot of that on agency. You go through a lot of that in your basic 101 real estate when you got your license. So reasonable skill and care, of course, loyalty, good faith, honesty, all those things. Okay. So read through it so you can quote it. Again, requirements of sections 339. Big deal. You need to read 339. It's really exciting. I've done it more than once, believe me. Okay. Again, we go here, and licensee acting as a seller or landlord's agent shall not disclose any confidential information about the client unless disclosure is required by state statute, rule, regulation, or failure to disclose the information would constitute a misrepresentation, or unless disclosure is necessary to defend the affiliate licensee, blah, blah, blah. Bottom line is, if your seller tells you, I am not, because this has happened to me, I will not sell to a certain client. You cannot do that. Or if your seller says, hey, no big deal, my basement leaks only when it rains, you got to tell them, listen, guy, we got to disclose that. Anything that affects the transaction. Now, one good thing, and I'm glad this popped in my mind, if you have permission to disclose certain things, yes, you can disclose the offers as they come in. You can disclose the terms. Make sure you get written permission. Make sure you have that in writing, okay? Because the seller could say, I didn't tell her they can do that. Everything is in writing, no matter how small it is, because you want to make sure that you're speaking the same language. How many times in your life you think you're saying something, or spouse, significant other, whatever, any kind of transaction or communication with a human being, you think you're saying one thing and somebody else is hearing something else. So there's nothing more powerful than when it's in writing. Everything's in writing. Everything. Okay. So go ahead and read through all those. And we're almost done. As authorized in Missouri broker disclosure form, designated broker authorizes its license to act as designated agents, and it appoints by the realtor designated brokers. Now, we were just having this conversation before. United Select Properties is the designated broker. Okay, so it's going to appoint, let's just say me, Janet, because we do designated agency. We keep on going back and forth on that. We have to make up our mind. A lot of people like designated agency. Some people don't like designated agency. Designated agency means that nobody else in my company except for me is representing this client. Okay, so it's really big. It's a big deal when you have franchises and a lot of different offices and that kind of a thing. Unless you have designated agency, everybody within Coldwell Banker Gunn-Daker represents that client, or everybody within a Keller Williams represents this client. So there's some advantages and disadvantages, and we'll talk about that in further detail. Now, another cool thing, if designated agency is appointed, the designated broker must sign this listing agreement. That's the negative. I gave you guys permission in the policies and procedures, which I'm sure everybody's read from page 1 to page 68. I think I amended it to. A lot of fun writing one of those. But I'm supposed to be signing every single one of your agreements. Now, I do have a call in because I've never practiced designated agency because I personally don't like it because it's a hassle, because I don't want you guys hung up, especially on a bank-owned property, of me signing a deal before it's fully executed. So for this particular class, we're going to have designated agency. Okay, so the teams sometimes like it because they can put it here. So for sake, because you guys know that I don't have a team, we're going to do this. And I have a call into MREC. It's kind of a rock between a hard place. Yes, I like to appoint designated agency, but no, I don't want to sign all the contracts. I don't know for sure if I'm allowed to do that. Okay. Okay, so we go down, owner signature, current address, zip, you have both people sign, of course, realtor company, which will be us. Never anybody else. I know a lot of the teams, you cannot, unless you're the designated broker, be on the contracts. Okay, so here we go. Here we talked about the authorized agent signature. The only time I have not allowed someone to have authorization and actually wrote an amendment to their independent contractor agreement was if they're brand new. I want to look at their paperwork before we proceed, or if you're on probation and I want to see everything that you're doing. This has happened. Okay, so we can, of course, we can't sign this signature here. We're going to date it today. And then your authorized email. Okay. Now, let's go back up here. I kind of went over it. Owner email address. This is the email address that all communication has to happen. Okay, so let's just say there's a disagreement or there's a confusion. The MREC will refer back only to that email address. Only to that email address. So make sure you're communicating within that email address. Okay? So this is the only, of course you're going to put the actual email, only email for communication that is authorized. Not text, guys. Doesn't ask for cell phone numbers here. email addresses for communication with transactions. I know a lot of people are not doing that. Let's just cross our fingers that nothing happens with that. Okay? And basically, that is it. This is your exclusive right to sell. Okay? I know there's going to be different questions. There's going to be different scenarios, different circumstances. One thing, since we've got about 6 minutes left, one thing that I like to see here, let's say you take a listing that you know is maybe $5,000 or $10,000 overpriced. I always put in here to review list price. In this market, I would do it weekly for further evaluation. Did I spell that right? Evaluation. Okay, so, and then you can even be really anal about it and say beginning, what's the date? So maybe 6/29/2017. Again, you guys, it's all about accountability. You're saying we're going to rock and roll. I'm getting this property on, which more likely you don't, it's great if you can get it on the same day. Keep that in mind. But you're going to market this aggressively. You can do the beginning of the date, or you can say 7 days after, let's just say if you put it on the market, you syndicate it on 6/23. Be as detailed as possible. Again, you're letting that seller know, Mr. and Mrs. Seller, be prepared, we're going to have this conversation. Okay? So another thing I've seen agents do is, which is kind of cool, I would like to put this on, my OCD's coming out, I like to put this on the second line. It's not letting me do that. Okay, so another thing you can put on here is, if you are 100%, or if you are happy 100%, whatever you want to say, satisfied, I did misspell that, with my performance, are you willing to give me a recommendation? Or you can put in there, I like a recommendation, because if they're going to give you a glowing recommendation, of course they're going to give you 2 referrals. Some people actually put that in there, referrals in the future. Again, this again is setting up the expectation of saying, listen, it's important for me enough that I want a future relationship. I actually have a separate addendum written up in my packets, but I want referrals from you. I want you to give me a recommendation. Of course, recommendations are huge. Testimonials, recommendations, you're going to use those everywhere. Okay, satisfied. Here, that's going to bug me. Let's take that out of there. So, again, you're driving the bus. You're taking control. You're setting the expectation of how things are going to happen. Now, people want to know here, the new agents that are on this right now, you guys want to know. You guys want to know this step by step. Of course, your clients want to know. I give tons of information and visuals up front, so it will set the right expectation. This is what's going to happen. This is what the sales contract. I even in my packets, guys, I used to give them sample sales contracts. Let them know and feel comfortable before you're in the heat of negotiations, or maybe a building inspection that's went wrong. Let them know that. Show them the other side of the transaction. Okay? It just makes everybody happy, more comfortable. And again, remember what I always say, fear is the greatest motivator. It takes, kind of eases that fear up a little bit. They have so much on their minds. We got to love on them and make sure they know everything they need to know. Okay, let me see if I have any questions. Right here. And I do not have any questions. Okay, so when you get into more the gist of it, again, this is only the listing contract. I'm going to show you the entire listing packet. We only have an hour, so I wanted to start with that immediately because this is the meat. And then we'll take it from there. Again, I'm always available. Send me an email with any questions, any concerns, or any scenarios that you want to share. Okay? Everybody have a great day, and I'll talk to you soon.